Hello, my name is attorney Dorna Taylor, and I've been practicing in the state of Georgia for 27 years representing families, businesses, entertainers, and other high net worth individuals. A big part of my practice has been wills and trusts for wealth preservation and estate planning and to preserve the assets that my clients have acquired throughout their careers. Now, I, like you, see so much misinformation on the internet about trust. Lots of folks asking questions and really getting no answers in the comments. The reason for that is the people generally talking about trust online are not attorneys and they cannot give you legal advice. And then there's me. So I'm here to give you some free legal information that will help you navigate and make some decisions that will really help your family move forward. I see it too often and you see it as well. We're starting over each generation. We're losing wealth. We're losing land. We're losing our grandmother's house to taxes. We see 80 family members owning 1/8 of an acre. We see far too many GoFundMes and not enough trust fund babies. So it's necessary to get the information to the community, and I just wanted to share it with you. Again, no obligation, no charge. The reason for that is I am a mother of two, but I'm also a widow. I lost my husband when I was 46, and he didn't have a will because we thought we had more time, and we were wrong. So part of my mission is to help other families not go through some of the things we had to experience. Thankfully now, I knew what I was doing and the process wasn't as bad as it could have been. I was able to navigate it, but obviously if you don't know, then what happens to your family and what happens to your wealth? A big question I get a lot is the difference between a will and a trust. I'll give you kind of some broad strokes and then I'll bring it down and explain it in great detail. A will is a public proceeding. Probate is required of every will signed and prepared. A will only becomes effective upon your death, and your assets can be frozen until the judge names the executor that you chose and gives them permission to go forward and take care of your family's affairs. A will does give you, though, the ability to distribute your assets to your heirs as you wish. You get to choose, and whatever your choices are, your executor can carry those out. So that's a very positive aspect of a will. Now, a trust is a completely private proceeding. There's no hearing, no probate, nothing's recorded, no public display of your assets, of who's getting what, where, and when. There also aren't any delays. A trust is very important when you own property in more than one state, because your estate would have to be probated in each state that you own property in. If you have a will and you own property in several states, your family could easily spend thousands and tens of thousands of dollars going from state to state handling the ancillary probate hearings. In your trust, there are no hearings. The other difference in a trust is that a trust is effective both during your lifetime and after your passing. So before we go into more detail, I want to explain to you what happens if you don't have a will or a trust and your assets become subject to the court process without any roadmap that you've left in the form of a will. The first thing you will experience is fees and delays. See, the state law determines who inherits your assets when you don't leave a roadmap to say what you want. If you're married, it's your spouse. If you're married and have children, your spouse and your children will share your assets equally. Now, that sounds great until you have, say, an older gentleman who's remarried, but his children are by his first wife. Now he's passed away and his new wife and his children own a property together, which is her home. We can imagine what are some of the options of what could happen there. So we want to leave that roadmap. Also, when you don't have a will or a trust, a bond is required. In the state of Georgia, that bond is $25,000 minimum in cash or assets. That can be the equity in the home, or it could be the home is, you have to take out a mortgage on the home to be able to come up with that. Additionally, the fact that you've passed away has to be published in the newspaper for 30 days upon your passing to allow anyone to come forward and say, that's my grandmother, or even American Express can come and say, they owe me money. So you have no privacy and you open your estate up for creditors to make claims. Now, the court process we call intestate when you die without a will is designed to appoint an administrator over your estate. Somebody will come forward. You won't really have any control over that after you've passed away. They'll file paperwork with the court and ask to be approved to be allowed to manage your affairs. It may be a child, it may be several of your children, it may be your spouse, but the court will make the final decision, and they may not choose the person that you would have chosen if you had had a will. The publication in the newspaper causes at least a 30-day delay. And some county courthouses are so backlogged that the delays run on for months. During that time, your assets are frozen before the hearing takes place, so this gets very expensive. Without having a plan, your family's going to spend at least $300 on filing fees, guardian ad litem fee, which is the appointed person who comes to make sure that minor children are in a good, safe environment. The publication fee for the newspaper that you don't even want is roughly $300 in most counties. And then remember that $25,000 minimum I talked to you about. Then there's the intangible cost, the emotional cost of your family having fights and disputes and not getting along. You really can't put a price on that. So when you have a will, you get to say, here's what I want. This is my executor. I'm married. I have 2 children. I want to give my blue couch to my sister and my car to my brother. Everything else goes to my children to share. You can also make guardrails for minor children. You can say, I want my children to inherit 10% of their inheritance at 18 and another 10% at 21 and 25 and 30 and so on. You get to minimize the disputes this way because you've left them some sort of map to follow. You get to choose your executor. The court will name whoever you named after they provide their ID and take an oath. You lose those 30 days that would have been required for the publication. But it does still have to go through the probate process, even though it's much shorter. You can waive that bond and you can waive reports as well. Now, conversely, when you have a living trust, you avoid the probate court altogether. Think of a trust like a Tupperware, that holds your assets, right? It's opaque. Nobody can see in, can't tell what's in there. You can look in the top, you have the cap, and you can take it off and put it on and put things in there and take things out. Someone that you've named, if you have an irrevocable trust, can do that for you. There are many types of trusts, but one other type I want to describe is irrevocable trust, which we use for Medicaid asset protection purposes. What happens with that is it's much more difficult to take the top off and put things in and take things out. But it provides a wonderful benefit for those of us who may later in life need long-term care, nursing home care. Oftentimes what people in our community do, if we think we may need to go into the nursing home, is we'll try to rush and quick claim our house to a family member. That's actually Medicaid fraud. We don't want to do that. The proper way to do that is to create an irrevocable asset protection trust that places your assets in the trust, names your relative the trustee, and then you may be able to qualify if you don't have other assets that disqualify you and if you've held it for the requisite period of time, which is generally 5 years in most states. Now, the other thing that's scary about that is when people just quick claim their property to a family member and they actually go to the nursing home, they may give you the care. They're not going to be inhumane. But after you pass away, oftentimes families get a bill for that care, which can be in the hundreds of thousands depending on the illness. So families are having to sell their inherited real estate to pay that off. That's not really what we want to have in mind. So there's a much more organized, structured strategy to protect that asset. So we have revocable trust where you can make changes and you can be your own trustee. And then as I've just described, we also have these asset protection trusts. Now, I don't know about you, but I don't really like that someone can have my address and find out that I live here and start sending me letters offering to buy my house, even though it's not for sale. Conversely, if someone knows your name, they can find your address. We get these scam letters all the time. And what's going on is that the property's in your name. Once we put it in a trust and we change the title, they don't know who it went to. You don't have to name the trust your name. You can give yourself a strategy to protect your identity with a trust. Now, a trust is a seamless process. Like I said, you can be your own trustee and you'll name successor trustees while you're doing your trust so that it flows right through from you to your pre-selected successor and second successor who take over and manage your affairs in the way that you intended. So this is the way to own nothing and control everything. And it's something the wealthy have been doing for eons. And I think it's high time everybody really have the benefit of this information. Sometimes I have people come on my Zooms and they say, well, I don't have much. And they'll go on to describe a $300,000 house and a $200,000 life insurance policy at their job. They've just named $500,000 in assets. Wouldn't their family want to have that as opposed to a GoFundMe? Now, there are several other documents that I really recommend you have if you do a complete estate plan. First is a healthcare power of attorney, a financial power of attorney, and those are just what they sound like, giving somebody the authority to speak for you if you can't speak for yourself in a hospital or a banking setting. There's also a living will, which is sometimes called an advance directive or a DNR. It allows you to preset your end-of-life choices. Do you want life support? Do you want your family to take you off of certain life support? Do you want ventilation? Do you want a feeding tube if you can't eat by mouth? Your family shouldn't have to make these decisions and hope they got it right. You can give them a map. You can give them a guideline. They can know what you want, so they can say, I carried out my mom or my dad's wishes. You can even go ahead and say, if you want to be cremated or buried, what about autopsy? All of this can be laid out, including your funeral plans if you wish. Now, when I do a trust, I do all of those, as well as 2 additional documents. When I do a will, I provide those documents with the will. With a trust, we have to have 2 more things. We have a pour-over will. If you want to think of that as like a saucer that sits underneath the Tupperware, and it catches all the things that we couldn't quite get into the trust that don't have title, like furniture and clothing and jewelry and personal property. So we can't put those in. All these assets are treated according to the instructions in the trust as opposed to going to probate. That pour-over will catches all the things that might slip through the cracks or pour over the saucer, as the case may be. And the last thing that causes people to, when they don't have qualified legal representation or they try to do this trust themselves, is the deed transferring the real estate to the trust. You can do all of this, and if nobody knows how to properly move that property from your name to the trust, your family will still end up in probate, even though you have a trust. So it's very important that you have competent, qualified legal representation with skills in this area. If you pass away before that's done, it's just too late. Now, I want to offer myself to help you. I've given you this information. I hope it's helped you. I also offer free one-on-one consultations via Zoom where we can get into the details and discuss your specific situation. I'll answer your questions. I'll give you free legal advice. You're in the comfort of your home. Everything is done via Zoom. If you choose to become a client, then we have a secure client portal that we communicate with you, documents, messages. You can request as many follow-up Zooms as you need. And most of my trusts are done within 30 days. Most of my wills are done within 10 or 15. I even offer payment plans because, again, I said I'm trying to do everything I can to get this information to our community. You can pay over time through a firm for 3 months, 6 months, 12 months, even 24 months, yes, 2 years. And that's a soft credit pull with no impact to your credit whatsoever. I will be honored to help you walk through this process. If you need a recap when you come on the Zoom, I'll give you a recap. I'll answer your questions. My goal is to give you guidance. Like I said in the beginning, I see so many people online, on Instagram, on Facebook, trying to accomplish the goal of getting the wealth from one generation to the next, but there's just nobody who's hands-on in those comments because, again, trusts are private. So these are not documents that GPT can pick up or people who don't practice this day to day. They just won't be able to do it because they just don't see them every day. So please reach out. Scan the QR code on the screen. It'll take you right to my calendar and you can self-select a time for you to sit with me on Zoom, one-on-one like this, and we'll have a conversation. I'll answer your questions and you'll leave there with a better understanding of exactly what a trust looks like for your family. Thank you for taking the time to watch this, and I look forward to seeing you on Zoom.